Okay, perfect. Now we are also live on Facebook. It's 2 o'clock. I think we are good to go. So thank you so much for joining us today, Bart. For those of you who don't know, Bart Zadel is a Social Security disability attorney with Morgan & Morgan based out of Florida. And he'll be joining us and speaking with us today about applying for Social Security disability. So I'm going to go ahead and jump right into it and start by introducing Social Security benefits. So I wanted to ask you, Bart, could you explain the difference for our audience between SSDI, Social Security disability income, and disability insurance, and SSI, supplemental security income?
Sure. Well, thank you. It's great to be here. The two different types of benefits have to do with your eligibility. The standard for proving whether you're disabled or not to Social Security is the same, but the two different types of programs are affected by where your benefits would come from and how much they what they would be determined to be. So Social Security disability insurance benefits, the amount you receive is based upon the taxes you paid as a worker, much like your retirement is. But there's also a standard of you have to have worked enough and close enough to when you became disabled in order to be eligible for those benefits. And then your monthly benefit would be determined based on your tax history, how much you've paid as a worker. The supplemental security income is a need-based benefit. So if you were approved to be disabled, but you have not worked either enough or close enough to the time you became disabled, you'd be eligible for a flat rate, but it would also be based on certain economic need factors. You would have to have no appreciable income and assets that were less than $2,000 as a single person. It's a little higher if you're married or if you have dependents. But basically, in addition to being found disabled, you would have to be found to have financial need. And then that SSI benefit is a static amount. It's the same for everyone, depending on whether you're single, if you have dependents, that type of thing. So the two benefits are identical when it comes to proving disability, but it's your eligibility and how much you get is the difference.
Perfect. That's a good segue into the next question, which is determining that eligibility. Could you explain what the Blue Book is and how it impacts a patient's ability to qualify for benefits?
Well, we don't call it the Blue Book anymore because they don't publish the Blue Book, but it's basically we call it the listing of impairments. And what Social Security has done is they have laid out certain conditions that if you can medically prove you have that condition, and then again medically prove that your symptoms or your limitations from that disease or disorder rise to a certain level, then you can be found disabled without any other evaluation, without any evaluation of your past work or things like that. Your condition is medically proved to be serious enough to make you eligible for disability. And there are 14 different categories in the listings of impairment. And within those categories, there are sub categories of disease or disorder that break it out a little bit. And they go into what is necessary to prove the disorder, and then what severity is necessary to show to be eligible under those listings.
I will definitely make sure to remove Blue Book from my vernacular. I did not know they no longer produce it, but I do know that those outlines and listings of qualifications still do exist. Is there a specific listing for Lyme disease, or will patients have to apply under maybe more of a symptom-based approach?
Well, I will tell you the listings are just one part of the evaluation Social Security does. It looks like we'll get into some of that later, but as far as a specific listing for Lyme disease, there is not. There is no disease that is specific under a diagnosis of Lyme disease or the limitations directly from it. However, there are many listings that people with Lyme disease and the typical symptoms that they suffer from could be evaluated under different listings. There's a cardiovascular listing, and Lyme carditis could be evaluated under that. Musculoskeletal disorders like arthritis, especially inflammatory arthritis, can be evaluated under the listings. Cognitive difficulties, memory or cognitive decline can be evaluated under a specific listing for cognitive abilities. And there's also a psychological listing. So depression or anxiety from dealing with chronic physical problems could be evaluated. So there are many symptoms that people with Lyme disease may suffer from that could be evaluated under the listing. It just wouldn't be specific to the Lyme disease.
Right. Thanks for making that clear. I think that's definitely important for patients to know, mainly because it took several so long to get the Lyme diagnosis that they think that that might be the best path to take. But obviously, focusing on what is actually debilitating you is going to be the best practice. So we've discussed, some of the financial qualifications and some of the listings of physical qualifications, but are there any other requirements that patients should know about when qualifying to see if they qualify for a Social Security disability?
Well, Social Security uses a 5-step approach to evaluate these claims. The first step is, are you working or not? And if you are working, you are by definition not disabled. So you do need to be out of work and unable to work in order to collect any kind of benefit from Social Security. There's no partial benefit. There's no short-term benefit. These deal with chronic disabilities and inability to work. The second category that Social Security looks at is, do you have a severe impairment? And a severe impairment is just anything that affects a person's ability to work. And I think that's something that a lot of the listeners probably don't think of or don't realize with Social Security disability is you do not have to prove where something came from or how you got it or that somebody's at fault for it. You don't have to prove that each individual condition keeps you from working. Social Security looks at all of the problems you have that are severe under that definition. They look at them in combination and then determine whether that combination of impairments keeps a person from working. So severe impairments are fairly easy to prove. If you have a knee injury, if you have arthritis, or you have difficulties with your heart and you're not able to walk very far or lift very much, those things are certainly going to affect work. They may not make you disabled, but they're severe. So then the third step is to look at that listing of impairments that we talked about, and do any of these conditions meet the severity for the listing? And if they do, you're then qualified for disability. The listings is a medical approach to these things, meaning that you have to have medical records or testing documentation, something that they can pinpoint that you meet these listing rules. So if you don't meet the listing, then they go on to more of a vocational evaluation. They would look then to see if you're able to do your past work, and if so, not disabled. If they determine you're not able to do your past work, then they would look and decide whether you could do any other kind of work in the national economy. Obviously, in accordance with your past work and any skills you have, they would find you could do work outside your skill set or things that you may not be capable of anymore. But if you are able to do a significant number of other jobs, then you would not be disabled. But if you get through all 5 of those steps, determining that there isn't any work in the national economy that you'd be able to perform the way it generally is performed, then you'd be found disabled. So a person with Lyme disease who doesn't meet a listing, but has several different types of symptoms, different body areas that are affected, and maybe even something outside of that, a prior injury that before the Lyme disease really didn't keep them from working, but now combined with everything else, causes another limitation. All of those things have to be considered. And if you can eventually prove to Social Security that all of those symptoms are of such a severity that they would keep you from doing any kind of what they call substantial gainful activity. That's essentially full-time work the way it's normally performed. So there is an additional duration requirement that you have to be out of work a year or expect to be out a year, have a condition that's going to be chronic, that's going to last more than a year or result in death. So if a problem you have, even if it's extremely severe, if treatment or time or surgery clears it up in less than a year, then you would not be eligible for disability from it.
Thank you. That was very helpful in clarifying who might actually be able to qualify. Now, to dig a little bit deeper, I'd be interested in outlining the application. So for a patient who might be considering applying for Social Security disability, what would you list as like the very first thing they should do?
Well, anybody who can get on the computer and go to ssa.gov, G-O-V, they can look at the application process without having to commit to doing any of it. It's very well outlined there what you would have to do, how you go about it, but most importantly, there is a checklist for the application process, all the information that you could expect to be asked by Social Security to complete an application. And so for anybody who is even if you're just investigating whether you want to file or not, that's the best place to start. And that checklist will tell you exactly what you need to get together before you can start the application process. And it's mostly personal information, your name, your address, your family, children, where you've lived. But they are also going to ask some vocational questions, your job history, your education. They will certainly ask about the conditions you have and any medical proof that you have documenting those things, the doctors you see, the medications you take. And then they will also ask some questions about your past work. They will want to know the types of work you've done, the skills you had. All of those things will factor into the decision they make. And you'll be asked those things many times throughout the process. But to start off with the very best chance, you want to make sure that application is as complete as possible. And so once you've gathered all of that information, there are 3 ways you can apply for Social Security disability. You can apply right on the site, ssa.gov. They will take you, the application will take you through all the information you need. You'll fill out an online application. You will supplement it with all of that information from the checklist. And then once it is done, Social Security will send you some forms that will require a wet signature that you'll have to send back. But once you start the process, that's the date your application begins. So even if it takes a little while to finish it or to get all the documentation done, that's the day you apply. So they don't rush you through it or make you do it in one day. And if you need some time, you can check out of the application. They'll give you a PIN, and then you can get right back into it at another time. Just make sure you write that PIN down. They don't save it for you. But they will tell you if you'd like to quit, that's fine. They'll give you a PIN. You can gather other information you might not have had, go back into the site and get right back into it. You can also call and do it over the phone. There, in that case, an agent would take you through the application and ask you all the questions and write them down. If you had to pause that, you would end up having to call back. You would need the same agent, but they would have to get back into the application and take you through it again. Same thing, they would have to send you some forms at the end. Doing it on the phone, it takes a while to go through it. So there's some fatigue to that, obviously, being on the phone. And doing it online certainly gives you the driver's seat as to how you want to do it, how much time you want to spend on it. It's certainly a lot less stressful because you can do it at your own pace. But either way, you can always have someone help you as well. You have to be there, but someone can help you get across the information or explain to the Social Security staff exactly what the information means or the particulars. Before COVID, you could also go in and file a claim and someone would help you do the application in person. But those offices haven't been open since the shutdown for COVID, and they are in the process of planning to reopen them. And once they do, I am sure that they will once again start taking the applications in person, but you cannot do that now.
Awesome. And in referencing that, I want to go ahead and drop a link into the chat for all attendees that are here. There's a resource on Project Lyme's website that'll take you directly to, as Bart was stating, there's a SSA screening tool as well as the application checklist. We have both of those links listed there, as well as some of the other information that we've been talking about so far. So I would definitely encourage you to check it out before taking next steps with the application. But to dig, Bart, even deeper into this, into the checklist and some of the documentation that is going to be needed for an application, could you discuss with me, in my opinion, it seems like a very important part of it is the list of medical conditions, doctors, healthcare professionals that you've worked with, like for a patient, how much work are they going to need to do in order to get that information before they actually do the application?
Well, Social Security is interested in the information, not the actual documentation. Okay. It is their job to collect that. But okay, what is very important is being complete. Social Security is not going to do any investigation on your part. They are not going to go looking for any doctors you might have forgotten to tell them about. So it is extremely important to be very complete when you list all of the different impairments you have. It's not just enough to say, I have Lyme disease. You would say, I have Lyme disease. I have inflammatory arthritis. I have cognitive list. I mean, all of the different limitations or restrictions that come from it, you want to lay out for them so that that goes into their file as complete as possible. Now, Things can always be added later. It doesn't have to be an exhaustive list. Things may come up as time goes on. That could always be changed. But you always want to be as complete as possible with the application, because that's where it all starts. And when they start to investigate your claim, they work from that list, not only of your impairments, but of your treating sources. So it is extremely important to be as complete as possible. Not just doctors, but therapists, physical therapists, chiropractors. The different types of providers are given different weight when it comes to evidence. A chiropractor is given much less weight than a specialist or an MD, but it's all important because it all sheds light on the severity of your symptoms, how frequently they happen, how chronic they are. So every single treating source you've seen in the year prior to when you stopped working up until the present, and the address, the phone number, how to get a hold of them, because Social Security will contact them to get those records. And if there's any, there's a problem with the address, you can't count on Social Security to do the investigation to find the right one. So you want to make sure they get all those records and know about all of your doctors, all of the treating sources, emergency rooms, hospitals, even a doctor you saw one time. Every time you see a medical professional, they have to create a record of it. And that record helps kind of flesh out to Social Security how all of these things are affecting, or the severity of them, proving their existence, that type of thing. Your medication, same thing. Have all the medications there when you're filling this out, right? The name, the dose, because it's not just the impairments you have. The side effects of the medications you have to take can be an impairment that affects your ability to work as well. Anybody who's ever had, narcotic painkillers, realize you can't drive on them. You can't think very well on those. So if you take medication, Social Security has to evaluate the side effects from those medications. Or if you get treatment and medication and you still have the conditions, that helps to show the chronic nature of it. So the medical information you provide needs to be very complete. That's where Social Security starts to evaluate and investigate your case. The work history is also very important, because if you get down into those fourth and fifth stages of their evaluation, they're going to need to determine what work you've done, and you want to make sure that they're not thinking that you have skills that you didn't get from a job. So just saying, I was a manager, if really all you did was take attendance when people showed up, you want to make sure you're clear with those jobs so that they evaluate them properly. They look at your work history for the last 15 years. So it's not may not be your whole work history, but the jobs you had the 15 years prior to becoming unable to work. So being as complete with that is important. What you did, how long you did it for, the duties. It's just the Social Security disability really is just a complete picture of the disabled worker. And is there proof that they're just not able to compete for employment or work the hours that everybody else can? And so there are so many things that go into that you really, at the application and even through the whole process, you want to make sure you're as complete and as accurate with Social Security as possible. It really is up to you, or if you have a representative, to make that clear to Social Security. They are there as fact finders. This is not an adversarial process, but they are not there to prove your disability in any sense.
That adversarial process, I think, is a perfect tee up for my next question, but I kind of want to lay the groundwork first in saying, when we as an organization, we're looking to provide resources for patients, not only on SSD, but then also insurance, like disability insurance, there is a clear divide there as to the process of being approved. Like the insurance side of things is definitely a lot more adversarial. If you can put in a complete application, have a clear disability, but still, if you are up against a good lawyer and you didn't follow the process exactly, there's still a possibility that you may not get any of your insurance benefits. So I'm asking this question for the Social Security disability side of things, is if you do everything right, have a complete application, is there anything that could still make your application fail?
Well, Social Security disability is a government benefit, and you are entitled to it like you are to some of the other benefits, either through the state or the federal government. But there is a vetting process, and so it is not adversarial. This is not you against them. They're not trying to prove you're not disabled. They're trying to determine whether you are. So there are several factors that I would say that make it very frustrating for people who feel or clearly feel they cannot work and feel they have clear proof of that. Social Security, deals with a lot of fraud like any other program, and they probably weigh anti-fraud measures more heavily than they probably should. And I'm an advocate for Social Security, people trying to get Social Security, so I may be a little biased, but fraud is on the minds of a lot of people at Social Security. So making sure that nobody's getting benefits that shouldn't is top of the priority list when they're evaluating these claims. Another thing is that many people file, and they haven't been out of work a year. So their conditions may be very serious, but they're denied at the earlier stages because they just haven't been out of work a year, like the duration requirement says. And it's Social Security just isn't, they are not geared towards approving a lot of these claims because there is a finite amount of money in the system, and they want to make sure that people really meet the requirements. And sometimes they just can't do that with just a look on paper, so to speak. So when you file a claim, the first decision that's made is what I call a paper decision. You're not able to go in there and talk to anybody. You're not able to go in there and argue your case. You give them information, they gather some other information, they look it up, they determine yes or no. If you're not disabled, then you are able to appeal that and have a similar paper decision where they gather more information and make a similar determination without your ability to appear anywhere or argue your case. If you're denied twice, then you could ask for a hearing with an administrative law judge. And that's what lawyers like me do, is represent people at these hearings when you do have a chance to go in front of someone, make your case, answer questions, present your arguments as to why you meet the rules. So the earlier decisions, those administrative decisions, there's not as much information gathered. These are not judges, these are caseworkers that evaluate them. So it can be very frustrating when you apply and you feel like you have a very strong case or you feel it's clear that you can't work. But it is important for people to remember that most cases don't get approved, that are approved, don't get approved at those early stages. The percentages are less than 20% at each initial, and then what they call reconsideration, which is the second decision. Less than 20% of those cases get approved. Yet, there's a lot more people than that are on disability. At hearing, the percentage of approval is much higher, and it's much easier to make that case. So the most important thing is, if you say what makes applications fail, it's probably people giving up, getting denied, thinking, how can they turn me down, and not realizing that it's going to take a bit more of a fight, that your best chance is further along in the process. So making sure that you file your applications, you continue to get that information in front of Social Security and give yourself every opportunity to prove your case and not giving up. That's number one. But number two is cooperation. Social Security is going to send a lot of requests for information to you as a claimant. And if you don't cooperate, that checklist goes in your file. Oh, never got this questionnaire back. They wouldn't go to this doctor we asked them to see. So making sure you cooperate with Social Security to fill all their requests for information and get everything back to them that they ask. And that way they don't have that excuse of non-cooperation that hurts, the evidence in your case. You want it to be judged solely on what's going on with your health and not, some perceived lack of participation in your.
Yeah, that's extremely helpful. I think a good follow-up to that is a typical timeline. I personally didn't know that there's these multiple phases and reconsiderations, having never applied myself. So that's extremely interesting. Obviously, for the 20% of people who get through the first phase, it's going to be a lot quicker. But on an average, like for people that you may work with, what is a typical timeline from putting that application in to actually seeing benefits?
Well, if you have to go to a hearing, which again, most people are approved do, that hearing will typically be maybe 18 months from the time you apply. Different for different areas of the country. It will depend on, each individual hearing office. Now, well, the one thing COVID has done is the judges pivoted very quickly to these remote hearings, and actually, because they're not doing a lot of their other duties, the time for a hearing has gone down quite a bit. So the judges are getting their hearings done much quicker, but the initial stages, because Social Security was slower sending people home to work and getting them up to speed with their homework, the initial stages have gotten a lot slower. So when you apply, typically I would tell people it's 3 to 4 months to get that first decision, another 3 to 4 months to get the second decision if you were denied, and then maybe a year after that to get your hearing scheduled, after you file that application. Now it's about 6 months at the initial and reconsideration phase or longer, and to get a hearing is much less than 12 months. So it's frustrating now for us because we have a lot of cases that are just languishing in these early stages where we know if we get them to hearing, we'll have a much better chance of winning, but they just can't get out of those early stages. So COVID has screwed up those timelines a bit. But historically, that's what I would tell you, 3 or 4 months through each of the initial stages, 12 months to get a hearing, about 18 months to go from start to a hearing. And if you're denied by the judge, there are still some appeals that can be done afterwards that have, obviously further timeframes, but that's the basic administrative process that most people go through.
Yeah, I'm sure as a patient, hearing that 18-month timeline could be a bit discouraging, but obviously it seems like in the long run, if you do everything right, continue to prove that you deserve these benefits, that fighting piece, it should help you get to the other side and see some sort of a benefit there.
Well, I can just add one thing too. What's important to remember is you're eligible for benefits based on when you apply. So for SSDI, Social Security Disability Insurance benefits, you can get paid benefits up to a year prior to your application, obviously no further back than when you last worked. So if you apply and it takes you 18 months to get approved, they're going to pay you for all those months you've been fighting. Right. So you receive a lump sum. Let's say it takes you 18 months to get approved. Whatever you're eligible for each month times 18, that's the first check you get. So that's how Social Security can get away with taking so long, is that they do eventually pay you for all of that time that you were disabled. They just do it in a lump sum if you're eventually approved. For supplemental security income, your back pay, that lump sum only goes back to the date of your application. No, not like SSDI that goes back a year prior.
Okay, I'm not sure if you just saw in the chat, but Avram said, please comment on SSA adjudicator's purpose in sending an applicant from an IME and the need to attend.
So we call them consultative exams, CEs. So I'm going to use that term so I don't screw myself up, but it is basically an independent medical exam. So Social Security is charged with investigating these claims, and they do that by looking at your medical evidence. But it has evolved into also including one of these consultative exams. So they will send you to a doctor that they pay, who is an independent doctor, but clearly these doctors do many, many Social Security exams. They're mostly internists, but sometimes they can get specialists to do more specialized testing. If you do not attend one of these, that's that kind of lack of cooperation I said that will really spell doom at these initial stages. That will almost guarantee a denial if you do not, attend the consultative exam. But these consultative exams are of limited use as well. They're very cursory exams. They don't pay for a lot of detailed testing. So it's typically an internist doing an examination and then an evaluation that includes diagnosis, some history that you tell them, maybe some examination results. But if it's not something like an eye test or a breathing test or an X-ray, it typically won't delve much deeper than that. But if the consultative examiner does find severe limitations, finds things that they feel a person would keep a person from working, those exams can certainly sway Social Security into approving a case early on. And DDS is the Disability Determination Services. Those are the caseworkers that get those cases at the early stages, who send people out for the exams, get the results back and review them. So the main thing with CEs is attend them, but don't be frustrated if they're not helpful, because ultimately your own doctor's records are more important.
Awesome. It looks like we have a couple other questions coming in, but I wanted to make sure that we take a quick opportunity to highlight you and Morgan & Morgan. And I think this will help to answer one of the questions about hiring a lawyer and and things like that. So with lawyers, I mean, it seems like you outlined it a bit already, is that you don't really get involved in the process until later. This is a unique comparison to like Social Security insurance, disability insurance, because lawyers are like the first thing that you're supposed to contact there. So the question from Aaron here is, do you have a better chance of being granted disability if you hire a lawyer from the beginning or after that stage one where you've been denied for the first time?
Well, obviously, I'm going to tell you have a better chance with a lawyer because that's what I do. But certainly, this process is complicated. It is long. There are a lot of frustrating both findings and communications from Social Security along the way that discourage people. And so, having an attorney help you stay the course, make sure everything gets done properly, help guide you as far as how to get information to Social Security, collect all of that information, give you the best chance in front of a judge. That's what we do. It's what we do as our vocation. All the attorneys that work here at Morgan & Morgan in the Social Security Department, that's all we do is Social Security. We're all very specialized in that discipline. And even though the attorneys, our job is to go to these hearings, that's what, we litigate these hearings. That's what the lawyerly part of our job is. But, here lawyers oversee all the whole facet of the case. So you will have a caseworker or a legal assistant who is helping you, and communicating with you, getting information, but they're all under the direction of attorneys that oversee the cases. And if there are questions about what Social Security has said or a decision, specific, things that go on with a case, that certainly goes up to an attorney to evaluate. But I do have a stat from this is before COVID, but I was interviewed once and they asked me that similar question, what are the advantages of having an attorney? And Social Security had sent out some statistics, I think in 2018, and don't quote me, but they basically, the statistics were if you were represented, you were approved at about 45% rate, unrepresented people at about 8.5%. And most people who were unrepresented, their cases were dismissed because they just didn't show up to hearings because cold feet or didn't know what to do. Those hearings are, again, they're not trials, they're not adversarial, but they're a Social Security judge that you have to convince. Knowing what rules apply, knowing how to take that evidence and slot it into the best arguments to make to the judge and to highlight what evidence shows what. There's also can be experts, vocational job experts or medical experts at these hearings that our attorneys, cross-examine and that the judges will use to try to show people can work. So there are just a whole lot of factors in these cases that to someone who doesn't deal with it a lot can be very confusing. And it's easy enough to kind of go along and do what Social Security asks you to do, but you don't know the extra things to put in there to highlight your file or to the arguments to make or what things that Social Security are saying may not be supported by the evidence, and they're just using it to turn you down. Those things are these government programs are designed with a lot of fail-safes, and they are all against the person applying. And knowing how to get through all of that and how to make the best case, that's the advantage an experienced Social Security representative can give someone.
I see we have, and I want to stress to everybody, we will make sure to get to your questions. I have one or two for Bart before we open to the audience Q&A session, but to further expand on how to get involved and leverage a lawyer for this process, can you explain a bit about Morgan & Morgan, the SSD specialty, and how you can work with patients from what we were talking about before the call, basically across the country on this process?
So Morgan & Morgan, we're a big law firm, and we have a department dedicated just to Social Security. So there are 15 lawyers presently. All we do is Social Security. All our staff does is Social Security. And before COVID, we would need to appear at these hearings in person. But since COVID sent everybody home, Social Security has shifted to doing remote hearings. So we do take cases now across the country here at these hearings, as do our clients remotely, either by phone or through a video chatting service like this. And the hearings are held remotely. A record is made. All the evidence is submitted to Social Security electronically. We have access to claimants' files electronically. So we're able to see everything just as if we were appearing in person, but you don't have to go and wait in the waiting room and do these hearings in person. They have no plans to go back to in-person hearings yet, but that will happen at some point. But we're hopeful that this ability to do remote hearings will remain. So as I was stating, even though the initial stages, you don't have an attorney out there arguing, there's no way, no court to go to, we do represent people at all stages of the process. If you call in and you haven't applied, but you've decided you want to, we're not going to tell you whether you should or not, but if you decided you want to apply, we can help you even right from the start, help you file the application, get the case going. Some representatives will tell you they don't want to take your case till you've been turned down. We evaluate the case for whether we can help you win it or not whether you need our help or not. You know whether you just need someone to file the application. So, or someone to file an appeal. Excuse me. So, we take the cases all the way to federal court if necessary. So we have experience and people who deal with every stage of the process. As I said, including filing the application. And if you are denied by Social Security through all of their administrative means, you can sue them in federal court to try to prove that they were wrong. And with selected cases, we can do that as well.
Awesome. Last question before we go to the audience is that what's the cost of patients for this? Like I know that
so legal fees for Social Security cases are regulated by Social Security. So any attorney that quotes you anything besides 25% with a cap of $6,000 of any back pay that you receive, that's the fee that Social Security allows us to charge. So any attorney who says, I'll do it for you hourly, or I'll do it for you for a lump sum, flat fee, that's illegal. Can't do that. So our fee has to be approved by Social Security, and it is always a contingency. So if we go to extraordinary levels, if we go to appeals to federal court, beyond that, we can ask to go above that 6,000 maximum, but never more than 25% of your back pay. So it is only if we're successful, if we win, and if there is back pay. So if you win very quickly and you just haven't been out of work enough to get any back pay, there wouldn't be a fee. Most lawyers will charge costs as well if they have to request medical records. If there are costs to prepare those, they'll forward those to a claimant, but that will be in addition to the fee if we're successful. So that is the fee for our work, like I said, is regulated by Social Security, and every attorney should be telling you the same thing when it comes to that.
I mean, it seems like it's a no-brainer that you should definitely work with an attorney on this process, just given the fee schedule that you outlined there. But I want to go ahead and open it up here. I've got a bunch of questions coming in. The first is going to be kind of a follow-up from Avram on the CE examination. He says, please comment on making sure that all medical records you want reviewed are submitted directly to the SSA named adjudicator and not left with the CE examiner.
Absolutely. Don't bring anything to the consultative examiner. They do not work for Social Security. They're an independent contractor that is paid only for that evaluation. So never give any information to anybody besides the Social Security contacts you're given with the case. You shouldn't be sent anywhere besides a consultative exam, but these medical records are very personal, and Social Security takes the confidentiality of these cases very, very seriously, just as a lawyer would. So you want to make sure that you are only sharing this information with those representatives from Social Security. And if you do have a representative, they have those same confidentiality rules, but we're bound by the same thing, sharing those records only with whom you want us to. The consultative examiner is a doctor. He would not make those public. He would be required to keep them safe, but also that examiner, she doesn't need to, she's not making any evaluations on what the past conditions are or things like that. They're simply they're doing an evaluation for Social Security as to what's wrong and what might be the limitations. So those records won't make it to Social Security to give them to the examiner. They won't help. So get all of those records and information to your caseworker. They will give a summary to the examiner so they know what they're looking for. But the only people that are really going to make use of them are the caseworkers, the staff at Social Security.
Awesome. So we have another one here from Sheila Statlander. I know we may have covered this at the beginning, but she may have joined late. Could you please clarify again the difference between SSDI and SSI and when the benefits begin, as well as what kind of health insurance is available?
Sure, I didn't. That's a good point. I didn't bring that up earlier. The SSDI benefits, or Social Security Disability Insurance benefits, the amount you get and the eligibility for that comes from your work history, your tax history that you've paid, the Social Security that's withheld from all of our checks. You have to have worked enough and have to have worked close enough to when you stop working to be eligible for those benefits. And the amount you get is based on how much you've paid in taxes. And if you are eligible for SSDI, then you become eventually eligible for Medicare, just as if you were retired. And then that Medicare is a choice. You have to pay a small premium for it, but you don't become eligible for Medicare until 2 years after you become eligible for the cash benefit. So from the time your back pay begins, 2 years from that, you would eventually become eligible for Medicare. Now, the supplemental security income, if you do not qualify for SSDI, you may qualify for SSI if you have no income or assets below $2,000, basically financially eligible according to the requirements. There is no eligibility for Medicare through SSI, but most states, including Florida, will make you eligible for Medicaid if you are approved for SSI. So while there's no federal benefit, most states will give you the state medical benefit if you're eligible for SSI.
Awesome. I want to comment that I know Sheila separately. She is actually a practicing physician. So this information will actually get back directly to patients. So thank you so much for answering that, Bart. There's another question I see here from Erin. It seems like she has actually gone through the process. After going through the appeals and receiving a denial after our hearing, our representative gave the option to completely start over with a brand new application. When is this valuable or recommended?
Well, when the first three decisions, the initial reconsideration and the hearing, each one of those decisions is a brand new evaluation of the whole case. Meaning, when you're denied the first time, when you file a new claim, they will start all over, and they'll make a whole brand new determination on any new evidence you want to collect. If you're denied at the second decision and you go to a hearing, the judge puts all the other decisions aside, looks at all the evidence again, and makes a brand new decision. So those are all you're given a very good chance each time, because they're not going to be biased by what was decided before. They're going to look at everything again, and anything new or anything worsening is going to help that case. If you're denied by the judge, you're eligible, you are entitled to appeal that decision, but that is an appeal and not a brand new decision. So you can only appeal the record that was made before the judge, and you can basically only appeal the decision that was made. You cannot, again, have the case reevaluated. So you can say the judge didn't evaluate the evidence properly, didn't comment on all the evidence, didn't include all the evidence in their decision, or the decision goes against the weight of all the evidence. Typical appeal issues. So if you feel like it was a very, very strong case in front of the judge, that he made one or several obvious errors in his decision, then filing an appeal is a better strategy, because if you are successful and eventually win, that back pay still goes back to your original application. So if you appeal, most of the time, if you're successful, it goes back for another hearing. And then if you convince the judge at that point, you get paid. Even if it's 5 or 6 years later, you're going to get all that money. If you feel like the decision by the judge is something you can't appeal, there's not a lot of errors you can point to, or your condition is getting much worse, and now the evidence is going to be much stronger, you can have all that new evidence looked at in a new application, but not an appeal. You can't submit anything new with an appeal. Also, when you get older, when you go above age 50 or age 55 or age 60, and the rules change in your favor, it's harder for Social Security to deny you. So you may have gotten into that older age group. You cannot make those arguments on appeal, but you could do it on a new application. So if the decision whether to appeal or not really comes down to, is my case just as strong going forward? Did the judge make some errors? If so, then file an appeal and fight that. But if the case is stronger now, or there's new evidence that makes it seem easier to prove, or your age has changed, or the decision just is harder to attack, it may be better to file a new claim and start over with that better chance. There are eligibility issues. You need to make sure that you're still eligible for benefits before you decide not to appeal. Sometimes that eligibility passes while your case is going, and an appeal is the only way to keep going, and you wouldn't be able to file a new claim. Those are more complicated issues than I want to get into here, but that's always a question to ask an attorney or Social Security if you're not represented is, am I still eligible if I file a new claim before deciding that?
Thank you so much. So it looks like that was all of the questions that we had coming in from our attendees. Just so everybody knows, this is being recorded. It'll be sent around sometime tomorrow. Bart, I want to ask you while you're here, can I send around your information as well?
Sure.
Okay, awesome. Not everybody who signed up is attended, so they'll be able to get this information to people who maybe had missed it or anything like that. So thank you so much for taking the time to educate not only myself, but all the patients who were able to attend with us today. I think this resource is going to be very valuable for our community moving forward.
Well, it's absolutely been my pleasure. Thank you.
Thanks, Bart. Have a good one. Bye-bye.